All right, welcome back to The Explainer. Today, we're diving into what I like to call the strategist's playbook for cracking really complex legal puzzles. If you've ever found yourself just staring at a massive, incredibly dense legal textbook and feeling totally overwhelmed, well, you're in exactly the right place. We're going to break down the structured research methods that actually take that raw, chaotic information and transform it into a winning legal argument.
So, what does legal research actually look like? When you hear the word research, what pops into your head? For a lot of us, it's one of two extremes, right? Either you're picturing very serious people in white lab coats staring intensely into microscopes, or, something super casual like spending 3 weeks Googling reviews before buying a new car. But here's the thing. Reading car magazines, that's just gathering information, not doing actual research. And in the human sciences, like law, you're way more likely to be holding a heavy book in your hand than a test tube. In law, research is a highly strategic operation of hunting down definitive answers and binding precedents.
Here is our roadmap for today. 1. What is legal research? 2. Scientific versus non-scientific methods. 3. Planning with the FIA system. 4. How to summarize a case. And 5. Reporting with the IRAC method. Okay, let's jump straight into Section 1. What is legal research? Fundamentally, research is a systematic process. It's not just sitting down and reading. It is about actively assessing, criticizing, and actually expanding on what we already know. Think of it like a strict three-step dance. First up, you pose a very specific question. Second, you go out and collect data to address that exact question. And third, you present an answer that actually increases our collective understanding of the whole issue. When we bring this into the legal world, it's all about finding that concrete answer to a legal question, or hunting down the perfect precedent to use in a trial. Moving right along to Section 2, scientific versus non-scientific methods. Now, there's a really clear battle line drawn when it comes to validating your research. Look, scientific legal research doesn't mean you need a literal laboratory. It just means your process is completely logical, objective, and precise. It's this rational, step-by-step process used to acquire new knowledge, producing findings that anyone else could consistently reproduce. On the flip side, we have non-scientific research. Some people call this pseudo research. It's haphazard, it's careless, and usually it's just based on casual observations, or worse, a researcher's mere hopes and faith. I mean, if your arguments aren't logically supported by empirical facts, you aren't doing scientific research. And honestly, those findings, they are absolutely not going to hold up in any legal setting. All right, Section 3, planning with the FIA system. Listen, any massive project needs a roadmap, right? In document-based legal research, you absolutely have to follow a systematic three-step cycle. You plan, you do, and you report. It is a totally linear journey. And the whole thing kicks off with the planning phase. This is where we organize the chaos before we ever start reading cases. To really conquer this planning phase, we use something called the FIA system. FIA. First up, facts. You have to establish exactly what happened. Strip away all the emotion and the angry shouting from the clients and just find the relevant sequence of events. Second, issues. What are the actual core legal questions at play here? Is it a private law matter, a public law matter? And finally, applicable law. Based on those facts and issues, where do we actually look? Like, if it's a divorce, obviously you head to family law. If it's a car accident, you might be dealing with the law of delict, or maybe criminal law. So as you can see, this workflow is incredibly straightforward. You push through those FIA steps, and as you do, please, you absolutely must keep track of your sources. There is literally nothing more agonizing than finding the perfect piece of information 2 hours before a deadline and completely forgetting where you read it. We've all been there. But by systematically organizing your facts, your issues, the applicable law, and your sources, you effortlessly arrive at a clear problem statement. Once you have that, boom, you are completely ready for the doing phase. Which brings us nicely to Section 4, how to summarize a case. The absolute most crucial point of this doing phase is captured perfectly by this metaphor. Just like a pile of bricks is not a house, a collection of facts is not research. You could have collected the most impressive stack of court documents and statutes in the world, but a pile of bricks is not a house. You can't just dump raw info onto a page. You have to evaluate it, understand it, and build something with it. In legal research, the main way we organize all that raw information is by summarizing case law effectively. Summarizing a case does two big things for you. It forces you to actually engage with the key legal issues,
And it makes recalling that information later 1,000 times easier. You should definitely be using this exact 5-point checklist. Start with the name of the case. Easy enough. Then, a brief summary of the facts. Now, be super careful here. Judges absolutely love to provide massive amounts of detail, but you have to be ruthless. Extract only the facts directly relevant to the legal issues and try to keep it to one single paragraph. Next, clearly articulate the legal question the court is answering. Usually, you can do this in just one sentence. Then comes the ratio decidendi, which we're going to unpack in a second. And finally, the finding, just a quick one-line summary of how the case was actually decided.
Okay, so let's talk about the absolutely most vital part of your case summary, the ratio decidendi. This is a Latin term that translates to the court's legal reason for its decision. And because of how the system of judicial precedent works, lower courts are completely bound by the previous decisions of higher courts. So legal research is actually way more interested in the judge's reasoning than in who simply won or lost the case. You have to separate this binding rule from what we call the obiter dicta, which are just remarks or opinions made by the judge in passing. They don't directly answer the core legal question. Finding that central legal principle, that ratio decidendi, that is the real meat of your research.
All right, final stretch. Section 5, reporting with the IRAC method.
So, we've meticulously planned everything, we've gathered and summarized our case law, and now it's time to build the house. Welcome to IRAC. This is basically the universal reporting standard in English-speaking countries. It dictates exactly how your final report needs to be structured. First, the issues. This is basically a refinement of that problem statement you crafted way back in the planning phase. Next, the rules. Here is where you summarize the applicable law, bringing together common law, legislation, and case law so they all relate to one another. Third is the application, and finally, the conclusion.
Now, this builds into arguably the most critical part of your entire report, the application phase. Students almost always find this step the hardest, but honestly, it is where the absolute magic happens. Look, there is zero point in discussing fascinating legal rules if you don't connect them directly back to your specific issues. You have to marry the facts of your problem with the rules you just dug up in your research. And you must provide clear, totally logical reasons for every single connection you make. Finally, you reach the conclusion. And this actually brings us to a really fascinating final thought for this explainer. You don't always have to solve the problem perfectly. Sometimes your incredibly rigorous scientific research is going to lead you to the conclusion that the law simply hasn't resolved this specific issue yet. And you know what? That is a perfectly legitimate, highly valuable conclusion. Pointing out unresolved problems is a massive part of what research is all about. It acts as a beacon, highlighting the gaps in our social framework and showing the next strategic legal mind exactly where they need to focus their energies. So the next time you hit a dead end in your research, I want you to ask yourself, is this really a failure, or have you just discovered the exact frontier where the law needs to evolve next?